my money is on the FBI as a former federal prosecutor. I'm not going to bet against the feds here, but it doesn't hurt to have a lot of media attention on a case like this. I know there's been a lot of criticism of, the search for Gabby Petito and all the other missing thousands of missing people in this country that really haven't received the same attention. But if you're law enforcement, you welcome public attention. You welcome those tips, even though there's a lot to sift through. And in fact, there was a missing person, unfortunately, a body found yesterday, not related to Gabby Petito or Brian Laundrie, but it was a result of this search. So it's certainly helpful for law enforcement in a case like this.
Millennials more interested in conservatorship law than you would ever imagine. Neama, do you think that this is going to lead to a reform as to conservatorship law in general, and maybe more scrutiny as someone who is appointed for someone's as a conservator, more scrutiny from the courts? What do you think?
No question, Imran, this is going to change the game when it comes to conservatorship. And this is happening literally 2 blocks down from my office here in Los Angeles. So I think everyone agrees, whether you're on the right or the left, you're having congressional hearings, you have Matt Gaetz on one side, you got AOC on the other. Everyone agrees that Britney Spears should not be under conservatorship and really shouldn't have been for the past 13 years. So yesterday was a big development because I know Britney wants her father out. I mean, he was previously conservator of both her person and her estate. He hasn't been the conservator of her person for quite some time, but he has been managing her finances. But really, what should happen on or before November 12th is for this conservatorship to end entirely. There is no reason one of the most successful entertainers of our generation should be in a position where she can't make decisions for herself or decide what she gets to spend her money on. So hopefully this is the beginning of the end.
Right. And Neama, on the other hand, there was a time in Britney Spears' life where she was clearly suffering from mental illness. And perhaps at that time, it was more appropriate that she was benefiting from a conservator of her estate in a trial that has been severed, and that is the other co-founder of Theranos. But she is pointing the finger a bit at that co-founder, Sunny Balwani, and also going into some of the relationship aspects that she had with Balwani, painting herself out to be somewhat of a victim in a toxic relationship. Do you think that that defense is going to fly in this case with all this evidence being presented in the Eastern District by federal prosecutors?
Neama, I don't think it's going to work. I love this case for the prosecution here. One of the biggest fraud cases, white collar cases, certainly since the pandemic, and obviously a very high profile one. I mean, Elizabeth Holmes really has two defenses here. The first is, I didn't know, right? I mean, that's usually the argument in these fraud cases and these misrepresentation cases. We talked about consciousness of guilt before, and what the feds want to do here is present these witnesses, and former employers are usually the best witnesses, up there with former spouses and ex-boyfriends and girlfriends, to testify that no, you knew that these statements were fraudulent to investors. So that's one defense. I didn't know. And the other, it wasn't me. I don't think it's a good defense. She's trying to point the finger at COO and ex-boyfriend Sunny Balwani, saying that he was psychologically and sexually manipulated. I don't think it's going to work. This is the CEO of the company. She's highly successful, educated, even though she dropped out of Stanford. So that's something that's probably going to piss off the jurors, but she's got a high-priced team out of Williams and Connolly. So we'll see if either of these arguments actually stick. I don't think they will.
The civilian witnesses, members of the Mennonite community, people who knew the victim, friends, members of the church come testify, and now they've moved on to the law enforcement and the forensic testimony. What do you think of the prosecution's case so far?
Imran, I like the prosecution's case. You always want to hit motive, means, and opportunity, and they're doing it. The motive, obviously, you mentioned those text messages with his law enforcement brother. Well, the means, and you're talking about it. Jurors love this type of forensic testimony. Someone that is detailing his car after a murder. You have the presence of blood in the vehicle, and obviously the opportunity, or someone who is certainly capable of killing. And all of this is going to come together. And not only that, you have the brother testify as an accessory after the fact, obstructing justice, getting the murder weapon. So you have a lot of evidence in this case if you're at the state of Arizona here.
The testimony about the blood on those vice grips, the jury is left on the prosecution's direct with perhaps thinking that this was Sasha Krause's blood, but the defense was clear to bring out that it was not her blood. The DNA match was actually to Mark Gooch. How important is that? And how do you think, on summation, the defense will now bring that back to perhaps create reasonable doubt as to the prosecution's case as a whole?
Neama, was a very important and effective prosecution by the defense. I don't think it's going to rise to the level of reasonable doubt, but a couple things happen here. First, when you're dealing with an expert as a defense attorney, you want to get in and out, score your points. You're not going to be able to beat them across the board because they are scientists and they know this area much better than you do. But they did get some very effective points out on the cross-examination. The first was the blood, as you mentioned. I mean, this is something that was arguably misleading. If you're a prosecutor on direct, the last thing you want to do is say, hey, there's blood on this instrument, and leave the jury thinking that it's the victims when it's actually the criminal defendants. That's something that you want to get out on direct. So I don't like how the prosecution handled it. And then, as a prosecutor in every case, the defense is going to talk about sloppy investigation. So when you have pieces of evidence, particularly forensics, like hair, that weren't examined, that's something that you need to anticipate as a prosecutor and get out on direct so the defense doesn't score those points.
By taking, certain actions of the text messages, which we're going to learn about in a bit, and also, the flying from Samuel Gooch down to Arizona to pick up the rifle, and this sort of familial animosity to the Mennonite community, which, if we're going to credit the prosecution's case, rose to the level of targeting a Mennonite woman seemingly at random and murdering her. Do you think that the prosecution, through Samuel Gooch, is aiding their narrative, their theory of the case in terms of motive by getting this testimony out?
Yes, Imran, especially in a case like this where there's no clear connection between the murderer and his victim. You have a criminal defendant who's a former military, is a vet, really no criminal history. So the jurors are going to be asking themselves why. And as a prosecutor, you need to tell a story. And a story in a murder case should usually involve motive when possible. So I like what the prosecution is doing with this particular witness, getting those bad facts out in a way that they really didn't with the previous witness that we were talking about.
Of the prosecution motive theory, how do you handle this as the defense attorney for your client? What are you doing to somehow put this away, or do you even confront it? What do you do?
Imran, very offensive. I mean, you have this hate speech. I mean, these religious bigots. I don't know how Acacia would handle a case like this, but this is really hard. And going back to an earlier point, absolutely, this should have been prosecuted as a hate crime. Prosecutors sometimes don't like to take that extra step. I've spoken to many of them. They say, well, we got first degree, we got second degree murder, and I say, no, no, no. These laws exist for a reason, to send a message, to protect religious minorities, people of color, folks like us on this panel. So it's morning that either the Fed or Arizona didn't charge this like they should, because frankly, they absolutely should have. This is a hate crime, and this is something that's very difficult to defend if you're a defense attorney.
Yeah, hate crime statutes are there for a reason, and I think this case checks off all the requisite elements and boxes.
Imran, not with respect to this particular witness. We've praised the defense previously on their cross-examination and scoring points, but not here. Really, there's not much you can do. You have the text. They're in writing. They speak for themselves. They involve a law enforcement officer making a traffic stop and issuing a reckless driving citation based on arguably someone's religion, which is completely inappropriate and just downright offensive. So not much the defense could do here, but they did try to sort of score a couple points, but they were not effective, at least with respect to this particular witness.
Yeah, or could it cause problems? Could it hinder the investigation, or bring some sort of issue and taint some evidence or what have you? What do you think?
Both ways, So we're talking about a young woman who was a vlogger, right, on YouTube, and was living this van life. So she already had a social media following, but this disappearance and now murder has really gripped the country. So you have thousands, maybe even millions of people out there that are following this case and looking for Gabby Petito. Well, obviously, she's been found, her remains, so the focus is now shifted to Brian Laundrie. Is he in the preserve? Is he hiding in some motel, or is he out of the country altogether? So the more eyes, the better as far as law enforcement is concerned in general. That being said, if they're impeding, obstructing the investigation, they take matters into their own hands, that can certainly cause a problem. But when you have a person of interest who's been charged with at least the use of the ATM cards and probably will ultimately be charged with murder, I mean, it can't hurt to have more eyes on this case.
The attorneys that we heard here, specifically Britney's attorney, Mr. Rosengart, he sort of alludes rather ominously as to possible other legal consequences for Britney Spears' father once they perhaps do a forensic investigation into these files that have been turned over. Do you think that his or her father may face some criminal consequences due to his alleged conduct?
Improprieties. Obviously, we haven't done the accounting. I'm not a forensic accountant, but ultimately, if that audit shows that Jamie was stealing money, there's no question he's facing civil liability as well as potential criminal liability. And not just that, let's talk about those secret and potentially illegal recordings. I mean, here in my home state of California, we're a two-party state, which means that both sides need to consent to a recording. Britney didn't consent. We may be dealing with civil and criminal penalties with respect to those recordings as well. So let's see what the audit shows. I don't want to sort of accuse anyone of anything improper, but what we do know is both Jamie, Sam Ingham, Britney's previous attorney, and others have made millions and millions of dollars off her estate. So they may have had a financial incentive to keep her under this conservatorship longer than necessary.
Do you think that you're going to see changes in the law as it relates to conservatorship and how, maybe a court will not be so quick to grant conservatorship status to someone without doing a deep dive into that person and possibly the way they would handle an individual's estate?
Imran, yes, we will see change in conservatorship law. The California state legislature is already addressing this issue. Congress is holding hearings on it as well. And let's talk about California law. To place someone under conservatorship, you need to meet what's called a clear and convincing standard. Not quite reasonable doubt, which is what we need to convict someone in a criminal case, but it's the next highest standard under the law. And it really has to be the last possible option. So someone has to be unable to take care of himself or herself or his or her finances. Again, that's not Britney Spears. That's not someone who's dropped 4 albums over the past 13 years or done a very successful Vegas residency. Not someone that's worth tens of millions of dollars, if not more. She really doesn't qualify legally or factually for a conservatorship, much less a 13-year conservatorship. So hopefully she gets out of this conservatorship soon. I applaud Matt Rosengart for removing Jamie, but ultimately Britney needs to be out entirely. There's no reason she should still be under conservatorship. And the fact that Jamie filed the petition to terminate it, but Rosengart did not, that's just a head scratcher, in my opinion.
In charge of her own life, her own financial future. Now, there is a past history of mental illness. Do you think that this is a bright future for Britney?
You know, Neama, obviously she's suffered through some mental illness. She's spoken about being on lithium herself. We're just speculating that maybe because of bipolar disorder. Obviously, I'm not a psychiatrist or psychologist, but just sort of reading the tea leaves here. But again, it's not a sufficient basis to place someone in a conservatorship. Remember, a conservatorship, you can't make any decisions for yourself. For instance, Britney just got engaged. She can't get married unless her conservator agrees. She can't have children. All the things that she's talked about when she's phoned into these court hearings. I don't care if she's 50 or had a suicide attempt. Again, not sufficient to place someone in a conservatorship under California law. Even though I'm a former prosecutor, I do civil plaintiffs work now, and I have clients that are currently under conservatorship, but they're in a coma. They're significant special needs or mental illness. Again, not Britney Spears. Not even close to being enough for her to be under conservatorship. So hopefully she can get this wrapped up before the end of the year, get married, have more children if she wants, and move on with her life just like everyone else.
Came out in this trial that Agent Morales, who was a witness who testified earlier, testified to, and that's the searches that Mark Gooch did on Facebook. He searched Facebook for missing persons posts. He looked at the Farmington PD Facebook article for a reward being offered for information about Sasha Krause. He looked at a specific post requesting information about Sasha Krause. Do you think that evidence is, the circumstantial case, but do you think that evidence is providing prosecution with even more ammunition in the evidence box, if you will, in proving their case and showing a criminality of Mark Gooch?
Yes, Imran, I love this evidence for the prosecution. And technology has really changed the game and given prosecutors and law enforcement more tools. I mean, the cell phone is everything, right? That cell site evidence that could put you just a few feet away from the scene of the crime. And that search history as well, really damning evidence for a criminal defendant who's searching for his murder victim before the investigation has even started by law enforcement. Very powerful stuff here.
Yeah, and I'm sure the defense will try to explain it away as innocent searches of Facebook. Just, Mark Gooch was interested in someone who's gone missing, and there's no nefarious purpose behind it. But I don't know if that's going to ring true with this jury of the question and sort of pivot or change their approach to the case as trial goes on. Or do you think it's a hindrance by having the jury ask the questions during the course of trial?
Imran, I know Kassia didn't like it. I got to tell you, it's interesting to me. Obviously, we don't have it here in California. And we have certain laws in California. For instance, we have an initiative process where voters can put a law on the ballot. And it really does get folks engaged in the election process a little bit more. And I don't think it's necessarily a bad thing. I'm sure jurors are going to ask inappropriate questions or questions that are barred by the rules of evidence. We see this all the time during deliberations when they're asking for something that the judge just does not allow. It can slow down the process, but also on the plus side, I think it gives some insight into the jurors because, as you know, we both try cases. Sometimes you talk to the jurors after a verdict and they consider something that wasn't even on your mind. And it also makes them a little bit more engaged as opposed to just being bystanders there. So I like it, although I've never gone through it. I can see sort of the criticism, but it's something that adds an interesting wrinkle, in my opinion.
Yeah, I think there's some pros and cons. And I agree with you completely about the jurors being engaged. When you're trying a case, I'm here in New York. We don't have this process in our trials. When you're trying a case, you're always worried that maybe the jurors are losing attention, losing focus, or not so engaged in the process in trial. This clearly allows the jury to be that extra next level of engaged because they are part of the process in terms of the testimony. But yeah, it gives insight. I think you could get insight, but I could also see some drawbacks, especially if you have your case in a certain way, and now you're being sort of thrown curveballs as things go on. Earlier about juries presenting questions to the witness. And Neama and I were talking about grand jury. When I was an ADA here in New York City in Brooklyn, I did a long stint as a grand jury ADA, and we would present cases to grand jury. The grand jury, they get to ask questions of witnesses in New York. And Neama, you had similar experience in your jurisdiction, correct?
Yeah, on the federal side, we use grand juries here in California. State side, we usually proceed by preliminary hearing. Most states on the West Coast do. But yeah, the grand jurors ask all sorts of questions. And obviously in the grand jury, it was just me or Imran or whatever prosecutor there is and the court reporter and your grand jurors. There's no opposing counsel, no defense attorney, no judge. So you really have to be careful about how you answer the questions because as a prosecutor, the grand jury is going to indict a ham sandwich. You're going to get your indictment. And the last thing you want is to put some objectionable evidence or something inappropriate before those grand jurors in the form of an answer to taint your indictment.
Yeah, no, absolutely. Because when those grand jury minutes get to that an astute defense attorney, they're going to look at that and say, well, you know what? It's tainted from the beginning, at least from the prosecutions, and this indictment needs to be thrown out. Now, I want to ask you really quick, Neama, your take on this trial generally. We're in sort of the middle of the prosecution's case. Do you think that they're going to have a conviction at the end of it?
Imran, I do. I like this case. Obviously, a circumstantial no body case, but I think those text messages, just the really offensive conduct regarding the Mennonites, that's going to turn off this jury. The fact that the brother has pled, all that doesn't bode well for the defense.
So you think guilty, right, Neama?
Absolutely.
Okay.
That's my prediction.
Right. Well, thank you for joining me, Neama. I'm going to have to